Good morning. I'm going to call the Legislative Committee on Administrative Rules to order. It's 8 a.m. March, the last day of March. It'll be a fun day tomorrow. First item on the agenda is to approve the minutes of March 10th, 2022. And before we do that, we will go around the table and introduce ourselves. Representative Higley.
Yeah, Representative Mark Higley, and I represent Lowell J. Westfield Troy in the town of Eden.
State Senator Joe Benning from the Caledonia County District, also from the town of Linden, which is about to become part of the Essex Senatorial District, but that's for the future.
Representative Seth Baumgartz, I represent Arlington, Manchester, Sandgate, and part of Sunderland.
Representative Carol Odie, I represent the far north end of Burlington, and I'm on the House Ways and Means Committee.
Senator Chris Bray, represent the Addison Senate District plus Huntington, which includes Huntington and Buell's Gore.
Jenny Lyons, Senator, representing Chittenden County.
Nancy Dexter Cooper from the Office of Legislative Counsel.
Mark McDonald representing Orange County, and the committees we serve on, which we did not share, cover a wide range of different committees, and each of the members of this committee brings a unique expertise to the rules procedure. First item of business is to convene and review the minutes. Do we have a motion?
Also moved.
Representative Baumgartz moves that the minutes be approved. Is there any discussion? If not, all in favor say aye.
Aye.
All opposed say nay, and the minutes have been approved. First item on the agenda, Department of Health Rules of the Board of Medical Practice, 21P34. The witness we have this morning is David Herlihy, Executive Director of the Vermont Board of Medical Practice. Is Mr. Herlihy here? Yes, he's
yes,
on.
I am.
He is on screen. Introduce yourself, please, and share with us what we need to know.
Good morning, Senator McDonald, all the members of the committee. I'm David Herlihy. I'm the Executive Director of the Board of Medical Practice, and I'm speaking to you this morning from my home in Fayston, and I'm happy to bring to you the current revision to our board rules. Over the past couple of years, we've had 3 different statute changes that have impacted us in a major way, and called for changes to our rules. Those 3 laws were a board bill, Act 126, and we also had a major change to our PA laws that were in their own bill, which I'm sure Senator Lyons remembers, and that was known as Act 123. And then there was also a statute change in Act 152 that affected all the professions, including ours, along with the many professions that are regulated by OPR. And so these changes, you've seen there's 75 pages now to our rules, and these there are many changes reflected in here. I think in the time at hand, I didn't even plan to try and do an overall summary of what they are. Just a few of the high points of things that really have significantly changed. The Act 152, the law that is styled as bringing uniform changes to professional licensing. We added sections for 3 of our professions regarding satisfaction of the licensing requirements by practice in another jurisdiction. Another major change that came about from a provision in our board bill was a section that allows for non-disciplinary financial penalties. And these are basically the board's version of fines for traffic offenses. So it's not like having a board disciplinary case brought against a licensee. And this is for matters that cause us problems and that are bad behavior, but that really don't rise to the level of having a formal disciplinary charge. These are things like failing to keep a good mailing address or telephone number on file with us. Most of the offenses that are listed for financial penalties are failures to disclose matters on their initial or renewal applications. There's also a provision in there about working without a license in the first 48 hours at the time of renewal. So again, just sort of the minor, more administrative offenses, and it allows us to address those without having a formal disciplinary action, which sets off a course of events for licensees, which is really difficult for them and not necessarily called for. We have a number of new provisions, additional ones that flow from the Uniform Licensing Standards bill. There's a section about pre-application determination on criminal background. That's for individuals who maybe have a criminal background, and either they want to find out before they attend an educational program trying to become licensed if they're going to be able to get licensed once they complete their education and training, or somebody who just wants to check before they spend the money for an application and see if that's going to disqualify them in this state. There's provisions about expedited licensure for spouses of U.S. military members who are ordered to Vermont and accompany their spouse here. And there's a provision about special fee waivers for military members who are ordered or have ties to Vermont and their spouses when they move. Another big part of the changes is rules for remote hearings. We've had emergency rules for remote hearings in place for almost a couple of years now. We've had our first remote hearing within the last year that was a fully contested hearing during COVID, and it was recognized that it would be a good idea to have these provisions in our rules available. They're a little bit different from the ones that we put in place under the emergency rules for COVID. During COVID, it basically said that all of our hearings during the pandemic emergency would be remote. This does not make all hearings automatically remote. It puts in a process for determining when remote hearings are appropriate, and also for handling objections by the parties if the parties don't want to have a remote hearing. And so that's a quick overview. Is there anybody that has any questions about our rules?
Do committee members have a question? Senator Benning.
Good morning. I was curious about the disciplinary action where there is a fine imposed. Is there a standard set of fines, or is this an ad hoc approach to any given incident? And where does the money end up going?
No, it actually, I'll answer both those questions. The statute called for a schedule of penalties. So there's actually, we spent a lot of time coming up identifying all these different, I call them traffic offenses, the more minor things. And we have them out. We have them all listed. What the fine is associated with each one of those, or not, I should say, non-disciplinary financial penalty. But for shorthand, we call them fines. And so there's there's not a lot of discretion. It's the discretion of the board saying, yeah, we're going to go ahead and do this. And they're all under $250. And I mean, some of them, failure to keep a mailing address or an email on file is $25. And actually, that one, it may sound like a small item, but my staff spends so much time tracking people down who fail to keep an address on file with us, that, it's just an effort to try and get people to do that. And it's actually probably going to impact the credentialing companies and telemedicine companies as much or more than any of our licensees. But and I'll just note that, I mean, this is not unique, having penalty like that. The Supreme Court, the Court Administrator's Office does that for attorneys. So I guess to just again, your question, how do you decide? There's a list, and it's very particular. Failure to disclose that you have a hospital discipline action on your application, or it's specific to that degree. All different kinds of these minor offenses. Where the money goes, it's where our the money from our disciplinary financial penalties goes. It goes into our funds, but it's segregated off, and there's limits in the law about how it can be used. It can only be used for educational programs and member education.
Thank you.
Any questions for the witness? Do we have a motion? Senator Bray.
Approval of Rule 21-234.
Bray has moved that the rules be approved. Senator Lyons.
Right, I just wanted to say, I'm not sure that I sent the approval in to Charlene, but I did. These rules do meet statutory intent.
Motion has been made that the rule be approved. Is there any further discussion? If not, all in favor say aye.
Aye.
All opposed say nay. The rule has been approved. Mr. Herlihy, thank you very much.
Thank you very much. Have a good day.
Next item on the agenda, 21P37, Department of Health Vital Records Rule. Natalie.Weill, Public Health Policy Advisor, is the witness from the Department of Health. Is that the correct pronunciation?
Close. It's Weill. Thank you, Mr. Chair.
I'm sorry, I didn't hear that.
Thank you. It's Weill. It's Weill, and thank
Weill.
you. Yeah.
The floor is yours.
Thank you very much. Mr. Chair and committee members, thank you so much for inviting me here today. My name is Natalie.Weill, and I'm a policy advisor with the Vermont Department of Health. With this filing, the department is proposing to amend the Vital Records Rule. The Vital Records Rule establishes requirements to create, obtain, and store birth and death certificates in Vermont. Act 15 of 2021 amended the law pertaining to vital records. Now the department must update our Vital Records Rule. To ensure consistency with statute, the department is proposing to update the list of eligible party members who may request certified copies of birth and death certificates to include employees of a public agency and registrants' grandchildren. We're also proposing to remove the section on the disposal of records. The department proposes to make 2 additional changes to the rule. Expand the list of alternate means of identification to include additional acceptable documents to increase accessibility to Vermonters. We also propose to update definitions to reflect current usages and for clarity. The department worked with the Vermont Municipal Clerks and Treasurers Association, who have reviewed and support this rule. With that, I'm happy to answer any questions you may have.
Do we have any questions for the witness? See, have these rules been updated and rewritten because a period of time has passed, or because something has come about that has prompted you to make some changes?
Thank you for your question. Act 15 of 2021 changed the law pertaining to vital records. So now the department must update our rule to be in compliance with statute.
Senator Bray.
If there's no more questions from the committee, I would move approval of Rule 21P37.
Senator Bray has moved that the rule be approved. Are there any further questions? Is there any discussion? If not, all those in favor say aye.
Aye.
All opposed say nay, and the rule has been approved. Thank you very much.
Thank you very much for your time.
2E03, Cannabis Control Board Rule 2, Regulation of Cannabis Establishments. David Scher, Assistant Attorney General, Cannabis Control Board. Scher, welcome back. I think you were on screen last time.
It was.
And you're here in person today.
It's good to be here.
The floor is yours.
Thank you, Mr. Chair. So Rule 2 is actually no longer in operation as an emergency rule. It is now in operation as a regular rule with full force and effect. It came into effect on March 29th after the 15-day waiting period subsequent to the completion of the adoption, which happened on March 14th. So I'm happy to discuss it further, but did just want to let the committee know that it is no longer an emergency rule, and we're operating under the final rule approval after this committee approved it, I believe on March 10th.
So we're gonna ask counsel to give us the legal implication. We have the emergency rule was in place. This will take its place when we approve it, or is it already somehow gotten approved somewhere before we've approved it?
So think back to the summer and when you were in a pickle with the rule on rulemaking, and there needed to be one more little bit of emergency rule on rulemaking because the permanent rule couldn't be adopted in time. So back in February, the Cannabis Control Board filed Rules 1 and 2 as permanent rules. You didn't have quorum at your February 24th meeting, and then you had your town break, and then you approved the rule on March 10th at your last meeting. Permanent rules under statute, the earliest that they can take effect is 15 days after they're adopted. So even though you approved it on March 10th, it took the CCB a little time to adopt the rule, have to file it with the Secretary of State, you would approve some modifications in your approval, and then 15 days later, March 29th. In the interim, and if you'll remember that fairly complicated 2-section amendment that Senate Finance made to H701, because the regulations for medical cannabis and the authority to have that was repealed from Title 18 and then recodified in Title 7, effective March 1st. And there was a hope that through the Budget Adjustment Act that could be postponed until July. There is a brief window where there were no rules applicable for medical cannabis. So what the CCB did was, under the authority in H701 for it deeming to meet the emergency rule standard, they adopted as emergency rules, Rule 2, the one you're talking about now, Rules 3 and 4, which you will be talking about in emergency rule form, and in permanent rule form. And that was because emergency rules take effect upon filings immediately. There's not that 15-day window. So this rule 22E2 was filed on March 15th. So from March 15th until March 29th, when the permanent rule became effective under its adoption, you're operating under the emergency rule iteration. You can still approve it, but it is no longer needed because there's a permanent rule that has already gone into effect as of 2 days ago.
And Anthea has written a quiz that she's going to give us next time we meet.
I gave you the highlights in the summary email. That's the extent of what you would need to know for the quiz.
So if we were to pass over this, we would be just fine, and we could get on to the next one. For those of you listening in, as a member of this committee for quite some time, this is a new one to me. Thank you, Anthea. And sometimes we find ourselves in such pickles. So is there a move to pass over?
Mr. Chair, if I could,
Mr. Representative Higley.
is this the appropriate time to talk about the letter on rule number 2 regarding certain committees looking at the warning labels?
Charlene has it on the agenda as the very last
Okay,
item.
okay. Nope.
Don't need to
We'll talk about it.
Thank you. Thank you for the reminder. Hearing no objection, then we will pass over this, being assured that the rule is in full effect, which brings us to E 22P02 Cannabis Control Board Rule 3. David Chair, Cannabis Control Board.
Thank you, Mr. Chair, and thanks to Legislative Council for giving a nice preview of some of what I'm going to say in this section as well. The committee is considering Rule 3 as both a permanent rule and an emergency rule. That is the immediate next item on the agenda here. And I'll get into the reason. I'm going to do a little overview of what Rule 3 is, and then get into why it's being followed as an emergency rule, which Legislative Council indicated already. And then obviously have to take questions.
Is this a similar train as the last one?
Not exactly the same.
Okay, it's not
because the
exactly.
timing is different, but the
withdraw my question.
concepts are
We're all ears.
are the same. So Rule 3 is the board's medical cannabis rule. As Legislative Council indicated, there has been a shift in the statutory scheme that governs medical cannabis in Vermont. It used to be under the supervision of the Department of Public Safety. As of March 1st, that supervision was removed from the Department of Public Safety and given over to the Cannabis Control Board. The board drafted and wrote Rule 3 in order to, under the direction of the legislation, to require the board to do that, and gave the board a couple of specific tasks in doing so. One, and this is, I believe, in 7 VSA 973. This is in 2 places in statute. The legislature directed the board to say, I shouldn't say that. They directed the board to keep the medical rules as consistent as possible with the adult use rules, and to make sure that the new medical rules that the board drafted was no more restrictive in any place than the prior rules that DPS had enacted to govern the medical cannabis system. So Board Rule 3 was working within those constraints, and I believe the board worked hard to do so. It covers 3 main topics. One is the registry, which is the patient registry and the caregiver registry. These are individuals who have certain qualifying conditions that are listed in the statute and are permitted to gain a patient card or a caregiver card if they have been registered under the rules to assist a patient with their care. That's one section of Rule 3. And the other main section of Rule 3 regards the dispensaries, which are the entities that are lawfully permitted to dispense cannabis products to patients or their caregivers. And again, this is all stuff that has been in existence for years, obviously with some changes through the years, but this law was originally passed in 2004, I believe, and has been and this basic structure has been in existence since, with a few changes here and there. And the board, in enacting its rules, tried to maintain as much consistency with the prior scheme as well, in order to have the least disruption possible for patients and caregivers in particular. So that is a basic overview of the rule. There are a few changes from the Department of Public Safety scheme, but those were primarily statutorily driven. The statutes did change a little bit when they shifted over, and so there have been a few changes. I wouldn't say they are not earth-shaking changes. They are primarily procedural changes, I would say. To give an example, one is that no patients are not required to make an appointment with a dispensary anymore, and they are not required to designate a dispensary where they're going to pick up the cannabis product or cannabis that they're purchasing. And I think these changes are primarily reflective of the fact that now that there is going to be an adult use market where any adult in Vermont can purchase cannabis at a cannabis store, it made some of the restrictions that had been in place under the prior medical scheme made less sense. So there were some statutory changes that reflect that. Otherwise, I do think that Rule 3, it is written very differently than the DPS rules, but retains a very similar overall structure of the regulations.
When you say written differently, it's organized in a different way.
That's exactly right. Yeah.
It's not that the message or the outcome is different. It's in a different format.
That's correct. I mean, there are some changes to how the dispensaries are regulated, because they do now have to fit in with some of the adult use rules in order, again, and that's in compliance with the legislative directive. But I would say it's primarily administrative differences as opposed to wholesale changes in policy or anything like that.
Any other questions for the witness? If not, Senator Bray has a doctor's appointment, so
I'll make a motion. I'll make a motion that we approve. Okay, which rule are we approving here? The
22P02.
I will make that motion to approve 22P02. Medical cannabis.
Senator Lyons has a motion to approve the rule as presented, and there's no further discussion. All those in favor say aye.
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 All those opposed say nay, and the rule has been approved.
Yeah.
22E04, Cannabis Control Board Rule 3, Medical Cannabis. David Chair, Assistant Attorney General, Cannabis Control Board.
Thank you, Mr. Chair. I won't restate my summary. This is the exact same rule, exactly the same drafting, no different. This does reflect the issue that the Legislative Council talked about a little bit before, which is that the statutes shifted over to the Cannabis Control Board on March 1st. And there's a need to fill the gap between, so that the dispensaries and patients and caregivers are operating under a workable set of rules between now and when Rule 3 becomes final, as a final rule with full force and effect. A little bit further explanation on that. The board was aware of this deadline, certainly. The original plan had been to pass an extension to the March 1st deadline, extended out into the summer, likely July 1st or something like that, in the Budget Adjustment Act. And so in that case, we wouldn't have needed any emergency rules. These rules would have been passed as regular rules and would have been ready to go when the shift happened. Budget Adjustment Act did not pass before March 1st, and after subsequent before March 1st. So the gap came into existence, And after further discussion, it was decided that it made the most sense, since these rules were drafted, had already been submitted to LCAR, were largely ready to go, to simply adopt them on an emergency basis pending the full adoption by the board and subsequent to the approval of this committee.
We need to act.
Yeah, this one, well, so thinking about whether or not you ever need to act on emergency rules, you don't really, because they become effective immediately. But this one became effective on March 15th, and the earliest that the rules that you approved today, the one you just voted on and Rule 4, even if they were adopted today, they're not going to be effective for 15 days. So you will have a gap going forward on this one. So this one I will act.
Are there any questions for the witness about the substance of the rules? Procedurally, we have been advised by counsel to act on this rule at this time. Is there a motion?
Well, I'm going to say first, Mr. Chair, I've been a member of LCAR for I think 6 years now, and I'm just realizing what the E stands for, 22. The P stands for in 22P03. I will move approval of 22E04.
Sarah Benning has moved the rule be approved. There's no discussion. All in favor, please say aye.
Aye.
All opposed, say nay. And the rule has been approved.
I know when you were chair of natural resources, Aaron Adler handed us a vocabulary list of everything that you could possibly run into in natural resources. Probably someday we ought to develop one of those for LCAR.
Yeah,
That would, if we had,
the acronym list.
Right.
Yeah.
that would, we'd have to have a longer meeting to go through that list. 21P03, Cannabis Control Board Rule 4. It's Rule 4 out of 5. We're making progress. Compliance and enforcement. David Chair, Cannabis Control Board.
Thank you again, Mr. Chair. So this is our compliance and enforcement rule. And this rule is what will allow the board to build a compliance scheme and to levy enforcement over actors in the adult use market and actors in the medical use market. So this rule provides enforcement for the first 3 rules, basically, at the Cannabis Control Board's regulatory scheme, rules 1, 2, and 3, which we've discussed already in this committee. Rule 4 does provide for a number of avenues for enforcement, essentially anything. It could range from a compliance plan all the way up to a revocation of a license. There could be, in between those 2 extremes, there could be a fine with a range that's described in the rule, and or ranges, I should say, that are described in the rule, or there could be a suspension of a license for a period of time as well. The rule also, before I say that next piece, let me back up and say that there is a section in the rule that talks about what the penalties would be for various types of violations, and the board listed out quite a number of potential violations that could occur and gave them ranges ranges both in terms of fine, in terms of severity of penalty based on how many times something had occurred. You know, if this is the second penalty, you face more harsh consequences, and that was in order to give actors in the market some reasonable notice about what their behavior, what their misbehavior might incur. It is not an exhaustive list. The board did give itself the authority to levy penalties even in the absence of a specific listing, because there could be something that has not been thought of, but that is a violation of the rules or the relevant laws that is deserving of some sort of a violation. But that is, we believe, a effective way to give notice to actors about what might happen if they do violate. Another portion, and then I should say another portion of the rule is the process. We do have to have some level of due process before levying a penalty, and so there's a section in there that talks about what the notice of violation will be if somebody does violate, talks about how somebody can respond and contest it, and the hearing process if the hearing is available to the person. And then after the board's process is done, it goes to an administrative law review, which is not in our purview, but that's just the way the statutes work, which is that once you're through the board process, you go up to administrative law judge to appeal if you want to do that. There is also the capacity for the board to impose penalties with immediate effect if there is a health and safety issue at stake, so that appeals process still occurs, but it occurs while the penalty is in force and effect. There's also a health and safety violations. So there could be there's a provision regarding health and safety violations. There could be, or I should say health and safety issues, because there could be times when the board identifies some sort of health or safety issue with some sort of a product. There's no clear evidence that anybody actually violated any of the provisions. For whatever reason, something happened or new information comes to light about some product that wasn't known previously. And so the board needs to act to remove that product from the shelves, to prevent it from being sold or require it to be destroyed. But there's no real violation that can be identified. So in those circumstances, the board is also empowered to act under Rule 4 to take action to protect public safety. And I think that's a pretty complete summary of Rule 4. When you dive into it, obviously there's a lot of procedural pieces there, because that always happens when you're talking about compliance and enforcement. But that is an overall summary of what Rule 4 does.
It's your bailiwick, Senator Benning. Questions?
So David, two questions actually. One, where does the money go if a fine is imposed? And secondly, you're embarking on something that everybody is waiting with bated breath to make sure it works right. And I'm curious, does the board have an internal procedure to, at every meeting, review how the rules are working, or are you taking literally a fire as it pops up and then reacting to it?
So far, what the board's approach has been is where there seems like there's going to be things that could be made smoother by changes changes to the rules in the future. There is already a list ongoing. It's so far pretty short, but we expect it to grow as this thing becomes real and we're actually trying to govern an active marketplace. That's the approach right now. I think that, and I acknowledge it's somewhat informal. I think it will make sense for the board to do reviews in a more formal way as the marketplace actually comes online.
The money.
Oh yeah, where does the money go?
Oh, the money, sorry. So I don't believe I might turn to legislative counsel for help. I don't believe that there is a provision in our statutes directing where it goes. And so my understanding of that is that it goes to the Treasury, but I could be mistaken if there's some other default pathway that the money goes to.
I'm gonna phone a friend and see if Michele Childs knows, but I certainly don't. I'm sorry. We're getting out of LCAR procedure.
Michele Childs.
Hello, good morning. So I don't think there is anything specifically in there that but I'll double check and I'll circle back with everybody.
We just don't want to be opening up a fund for the Cannabis Control Board's annual Christmas party.
Oh, I think that's.
I don't recall putting that in the legislation.
From other experience in state government, not from this current job, I do not believe, if there's no provision, I do not believe that the agency controls the penalty revenue, but I can check on that and get an answer for you.
Well, it may be something to address in a way that it comes back to the board with a specific purpose. I don't recall us dealing with that in legislation, but it may end up having to be dealt with in rules.
Were LCAR to approve this rule, would we hear before our next meeting the answer to the question asked?
Yeah, I can certainly get you an answer for that, yes. And again, I think it's going to be a default answer. In other words, this is what happens anywhere where there's penalties that are allowed, but no provision for where they go. I think it's the default is going to be to the treasurer's office, but I will confirm that for the committee as soon as I can.
Seeing no other hands, Mr. Chair, I'll move we approve 22 P03.
The 21 or 22?
I have 22 P03.
Can I just jump in, because they did propose some additional modifications, if you want them to make them.
Okay.
The Cannabis Control Board filed a memorandum. Charlene has printed out, and you have it. It was something that Ledge Council found probably very nitpicky, but we in statute refer to penalties that are not criminal as penalties and administrative penalty. And I apologize to the CCB for the fact that I suggested that they change it, because I think it ended up being a lot of last minute changing to the rules. But I like to think that we're adding value, and that it's kind of a pain to go through the rulemaking process, and it takes 8 months usually. So we might as well try and get the rule to be technically correct at the outset.
So you would characterize them as technical changes?
Oh, they're super technical.
Intending to make the rule function as it was presented to us and testified to us.
That's exactly right. Is essentially bringing the rule in line with standard legal usage in Vermont with respect to what do you call a monetary penalty in the non-criminal context.
And could you reference the document, please?
So the memorandum was March 30th, 2020. I have the suggested motion language in my email, and I would suggest it be something along the lines of, I move that we approve the rule with the modifications proposed by the Cannabis Control Board and correspondence from David Chair dated March 30th, 2022. If I was making a motion.
Thank you, Senator Bennett. And thank you, Anthea. And for the public, once again, this is not a policy change. After other minds set a direction, that direction has to be charted in a way that fits statute and is compatible with how administrations and the public read statutes. So that's the purpose of the such changes. Is there any discussion? All those in favor of the motion, say aye.
Aye.
All opposed, say nay. And the rule has been approved with the technical changes, the aforementioned technical changes. Thank you. Which brings us to
Deja vu again. You're gonna have deja vu again.
22E05 Cannabis Control Board. David Chair.
Thank you, Mr.
This is
Chair.
the last thing you have to share with us.
That's good, very good. If I could simply import cut and paste my testimony from 22E04 and put it under here in 22E05, I would. It is exactly the same issue that we confronted there, where there is this regulatory gap that we're trying to fill until this rule becomes a final rule in full force and effect. And by this rule, I mean Rule 4. So it's exactly the same issue as Rule 3, just replace the term Rule 3 with the term Rule 4, and you have the testimony for this one as well. I'm happy to clarify further to whatever extent that is helpful.
Yeah, and then this one, unlike 22E02, this one you will have the gap because the rule you just approved will not become effective for 15 days.
Okay.
Oh, okay. Not seeing any hands for questions, I will move approval of 22E05.
Thank you, Senator Bennett. Is there any further discussion or any further questions? All those in favor, please say aye.
Aye.
Those opposed, please say nay. And that brings us to review of the draft memorandum of the committees of jurisdiction, as referenced earlier by Representative Higley, and at the request of Representative Higley, we have a draft.
I believe did Charlene include it in your package? I'm not sure. I emailed it out.
You reviewed it? Have you reviewed it? Yes.
And it is in your package.
So would you,
Sure.
Representative Higley, would you comment
Yeah, no,
on
I
the work that
appreciate-
you have brought to us.
Yeah, I appreciate the letters going out. The only question or concern that I have is it talks about, getting this for review during a 2022 or 2023 legislative session. And I'm just wondering, I know we're, getting into the tail end of this session, but what's the length of process if, the committees do determine that there's a different warning label? We're gonna have to go through the whole rulemaking process again, and so we're talking about a pretty lengthy timeline, and I'm just wondering if we shouldn't just keep that to the 2022 session. And I don't know what work that means for the committees between now and the end of the session, but that's my only concern, is that if we're gonna do this, it sounds like there's some concern from Dr. Herlihy and others that have looked at other states as to what that actual warning label in particular is. And that's my only question, is whether or not we should tighten up the timeline for it. Just open for discussion on that. That's it.
So, Representative Higley, if would you seek to have a different draft notification presented to a legislative committee sooner rather than later, for the committee to either act upon or to say no thank you, or yes, we'd like to do it? Is that
I
what you
would, but again, I appreciate discussion from other folks who maybe have more familiarity with the current workload of committees and so on.
But that's basically the issue here.
Yeah.
Would it help if I talked a little bit about
It
the
would.
procedure? So if you're sending this memorandum, you're sending it under the just authority that LCAR has to send requests to committees of jurisdiction. The committees of jurisdiction are not required to take it up just because LCAR sends them something asking them to do it. So there's that as the initial piece. So even if you say take it up in 2022, it doesn't mean that they have to in the balance of the bit of session that we have left. In terms of how the warning label that is in Rule 2 could be changed, it could be changed through rulemaking, and that would either be emergency rulemaking taking effect immediately, or it would be permanent rulemaking again. And I think eventually it would need to be permanent rulemaking, and that takes a long time because there needs to be opportunity for the public to comment. And there needs to be the ability for it to go to LCAR and everything that needs to happen through the Administrative Procedure Act in terms of adopting permanent rules. If the General Assembly wanted to change the warning label through statute, that is something that could happen in the balance of the session, because that's not something that needs to go through the rulemaking process. However, it seems like there was a conscious decision when the statutes for the adult use market were put into place that the warning label was something that was left to, and I would need to look to Michele and David in terms of, I think there was supposed to be consultation with the Department of Health, and that happened as part of the development of this rule. So you would be deviating from the statutory process that was contemplated 2 sessions ago, and I'm not saying you can't do that if you were to then have the warning label be something that was changed through statute as opposed to the rulemaking process as it was contemplated originally. So some of the procedural factors to think about in addition to the logistical factors and the time of the year factor.
Okay, thanks.
Senator Lyons.
So asking the legislature to make a change to the labeling and then putting the labeling into statute is somewhat contrary to the discussion that we've had in the past about allowing for the Cannabis Control Board to regulate and to be in charge. So may I ask David Scheer a question? And the question may have been asked at the last meeting, I don't know. So will based on the discussion that's happened, will the board be discussing and talking about the label itself and taking into consideration the concerns that have been brought forward?
I'm sure, so in future years, the board will be revisiting all of its rules. And I'm sure when it does, in order to make sure that they are current and make sense with with how things are operating, And I'm sure that in doing that, I'm guessing that in doing that, they will also revisit things like the warning labels. They're not, the rule is the rule now. So it's not, the current warning label isn't going to change unless the legislature were to act. And I do want to emphasize that the current warning label was created with the explicit approval. We consulted with the Department of Health and acted with their approval in putting forth this warning label. We understand, of course, there are differing views about what the warning label should have, but those were presented. The department did consider them, and the label that is in the rule is the product of that consideration.
So it sounds like the process that the letter is asking for is something that you've already done. I'm trying to sort that out. I'm wondering about the value of having the conversation. I just know what my committee is doing right now. I don't know that this would be something we could accomplish before the end of this session. But it's certainly something that, you know, reviewing what the Cannabis Board is doing overall might be something going forward that we would, you know, just to have that initial oversight of the board. But so I'm saying I don't think 2022 is a good suggestion. I also think that the board is in the very early stages of its development. So there are a lot of concerns, I think, that a number of constituencies could bring about any part of the board rules, and until we see them and you know, actually on the ground, boots on the ground, it's going to be hard to say that we should change something. So,
I'm going to try and someone is think this before us, because Representative Higley, they were asked the questions at the last meeting. There seemed to be two schools of thought. One was that the warning had a lot of words in it. Print was kind of small. People might be less likely to read it, and versus one that was shorter and more to a particular point. And then the second one was there were, I think, on one side there were folks that wanted to have the warning highlight some concerns more in highlights,
Yeah.
and that the other method tended to have things get lost. And Representative Higley wanted the Committee of Jurisdiction to take a look at it and say, you know, no, that's what we intended, or no, maybe there's a point here, and we, the committee, would consider making a change. And so I would go back to Representative Higley and say, which would you like to have a letter go now and say, ask them to take a look at it this year, or have it be 2 years?
No, and I appreciate the discussion, I think, from, you know, what you've said and so on, that the 2023 years is more realistic. And if you're explaining the two different ways that it could possibly go down, that helps as well. So I'm comfortable with the letter.
Well, okay. And that's why we write the letters to when someone has a concern that we feel is worth pursuing. Okay.
Again, I appreciate that.
So we have Senator Bennett.
Well, I just wanted to get a clarification because I heard David say something that I was not aware of. Were you present for Dr. Ankney's testimony last time we were here on this?
I was on the screen.
The conversation went towards Colorado having changed its warning label. And if I heard you correctly, you've just said that the letter, the label that the board has gone with came about as a result of taking all of these things into consideration. Was that one of the things that was taken into consideration, the statement that Colorado had changed its warning label?
That was not, because that came about after the consultation, after the decision had been made in consultation with the Department of Health. That's very recent.
Well, as one of the people who has spearheaded this whole process for several years now, I know from the get-go, we took considerable testimony from Colorado. And the conversation was always geared toward doing what Colorado did, but doing it better and making sure we learn from their mistakes. So I don't have any problem advancing a conversation somewhere and signing this letter to have that, because we want to do it right. We don't want it to be done wrong. And if Colorado found some reason to change, we should be thinking about that too.
Now, if we had 5 people here, we'd perhaps ask the letter to be note that Colorado, since this letter was drafted, has made some changes that might be worth looking at. Do we?
You can tell me to change the letter all you want. What you can't do is tell me to send it, because
Yeah.
you need a majority of the entire committee under statute. So this does specifically say written oral testimony also just recent statutory and regulatory changes from other states, including Colorado. And it does not call out in the last paragraph with the request, but you could say, we request that these committees review during the 2022 or 2023 legislative session, section 2.2.10, the contents of the cannabis warning labels and packaging requirements in other states. You could then say, including Colorado again, and any recent statutory changes or regulatory changes or both from other states, including Colorado, if you really want to highlight.
Are we meeting next week?
Yes.
Yeah, so we meet
Sure,
7
we're
days.
meeting next week, right?
Okay. We lost our quorum.
If
I'm
I
sorry,
could-
because we could have.
Right, well, no, if we can change the letter, I would suggest tweaking it, because obviously they considered a given set of facts in front of them when they made the rule. There has been a substantial change in another state that we have looked to for guidance on this question, and we ought to take those.
Okay, I'll add in Colorado in the last paragraph in addition to the middle paragraph.
Okay.
And then we'll take care of that next week. And by golly, we'll maybe do it at the beginning of the meeting and make sure it doesn't, because our session's running short, so.
Yeah, oh yeah, appreciate it.
So, well, enough people to officially adjourn. We have